seated.
All right, we are back on. Defendants present. Got two lawyers up. I assume you're calling your witness, or is there something for the court?
It's something for the court, Your Honor.
Okay. From the state first, I'll work around.
Thank you, Judge. Your Honor, the next set of witnesses are lay witnesses, and the state filed its brief 4.72 on October 18th of 2021. These witnesses are in no way character witnesses about Ahmaud Arbery. These witnesses are intended specifically by the state to provide facts about their knowledge of Mr. Arbery and that he was an avid runner. The defense has been beating a drum repeatedly that the state is going to open the door by putting these witnesses up, and that the state will somehow inadvertently do something that would cause the defense to be able to walk through that door. And out of an abundance of caution, I filed this brief just to make sure that we were all on the same page, because I don't know what cross-examination questions are going to be asked of regular people, and I don't know what their responses are going to be to cross-examination questions. So I just wanted it on the record. And this is, of course, per Montgomery versus the state, 350 Georgia App 244, a 2019 case about the way to handle non-responsive answers from witnesses who may inadvertently say something that the other side considers to be good character evidence. And in that particular case, they said the party has to have the intention to put this person up as a character witness, and the other side does not get to go gotcha and put in evidence that's been excluded simply because of that. In addition, in Strong versus the state, 309 Georgia 295, a 2020 case, if inadmissible evidence were to come in, the opposing party must object, because you can't just consent to, well, inadmissible evidence came in and I didn't object to it, now I get to put in additional inadmissible evidence. And that is what the Strong case held. So, Your Honor, we have no intention of eliciting reputation or opinion testimony or good character testimony at all from these witnesses. They are strictly fact witnesses. And the reason they're fact witnesses, and this is a relevant issue, is because the defense has put in evidence that Mr. Arbery walked into the neighborhood. They have not conceded in any way that he was a runner and or a jogger. This is now, because of the defense and their openings and the way they presented this evidence, an issue in dispute. So at this time, we feel it's relevant that he was in fact a runner slash jogger. We're not intending to elicit why he did these things or what they were for. It's just a fact that he was that person. And so we just direct you to our brief if this were to become an issue. We do not wish it to be, and we don't anticipate that happening. But once again, these are non-law enforcement regular folks who are going to be taking the stand now. Thank you, Judge.
Good morning, Your Honor. So I thought the court had ruled pre-trial that Mr. Arbery's intent in the neighborhood that day was not a matter before the jury and was not relevant. We didn't put in evidence that Mr. Arbery walked in the neighborhood. The state did. So I thought we weren't getting into Mr. Arbery's intent in the neighborhood that day, Mr. Arbery's intent in the house that day. The court forbid us from putting in evidence about those things. So what's the relevance of the state's witnesses to say that he's a jogger? The court's already ruled that's irrelevant. Now, any witness that testifies will be subject to cross-examination. I'm not going to trick a witness into answering questions that open the door. I understand how the law works, but I don't see the relevance here. where the court has specifically said his intent in the neighborhood that day is irrelevant to this trial.
Mr. Hook.
Your Honor, just to adopt the argument made by Travis McMichael's attorney on behalf of Greg McMichael, I do so now. And just add it into it a couple of corrections. We've not argued that Ahmaud Arbery walked into the Satilla Shores neighborhood. What we've argued is that the state introduced a video that shows him walking into the yard and up to the house at 220 Satilla Drive. He may have walked into the neighborhood and walked to the house. He may have run into the neighborhood, but the video we have is of him walking down the street and then into the yard and into the house. And that's the first one. The second response to his being an avid runner or jogger, it's logically true that he could be both an avid runner and avid jogger. In fact, we don't have any reason to dispute that. But that on some occasions, when he engages in the activity we call running or jogging, he's doing it for other motives besides physical, mental health, or whatever other reasons a runner would run. And we've offered those before. I made an argument here, seems like a month ago, but it was probably 2 weeks ago. And it goes to this issue, and then I'm done. The state says, by offering this evidence, this is an answer to why was he running on 2/23/20. I mean, the evidence is meant to allow an inference to be made in argument that on this occasion, on that day, his motivation for running is the same one as on many other days when he ran for mental health or physical health. And we have some evidence that so far we've not been allowed to introduce to suggest, well, there may be a different answer to that why question than the one the state wants to argue from the inference they'll make that he's an avid jogger on other days, therefore he was jogging on this day. Under 401, it's simply not relevant. And if it's a balance test under 403, then it ought to open the door to the defense at least to offer an alternative explanation for it.
Mr. Shaw.
Your Honor, we join in the motion as made by Mr. Sheffield and in the further response by Mr. Hogue.
All right, let me do this because I have my, I don't remember a formal response coming in from the defendants that was more of an advisory brief that was submitted, correct?
You mean the state? What the state wrote?
Correct.
I think the state was just trying to identify this
The
issue
issue
could
as
come
it
up.
came
We
up.
did not
Okay.
respond with our own.
Except we did file motions regarding the admissibility of Mr. Arbery's being on probation as the alternative explanation for his running. So in a way, we did respond.
Addressed just before trial. Yes.
And I do believe there was a filed response to this issue concerning 404B character and whether or not the introduction of what was going on in Ahmaud's mind and speculation about why he was in Satilla Shores can't come in because, for the same reasons that the court would not allow the 404B evidence of the defense in, because the argument of the state has always been and the court's conclusion has always been what Ahmaud Arbery was thinking that day is not relevant in this case.
Let me, I can take a short recess. Let me look at what I have. I've got a notebook in the back with all the submissions. I just want to make sure I'm clear on what I have and based on the arguments made here, come back with a ruling. All right, we're in recess, hopefully very brief. we're back on. Defendants are all present. All right, I took another look at 4.72, which is the brief that the state had filed on character witnesses and opening the door in consideration of what I have heard this morning. So I do have a question before I get too much further. The brief that was submitted indicates that these lay witnesses that the state intends to present, and I will read from 4.72. State's anticipating the lay witnesses who knew Mr. Arbery personal or who saw him running or jogging in his neighborhood or in the surrounding neighborhoods in Brunswick, Georgia. What is the proffer on these lay witnesses? Are we talking about just generally running, or are we talking about in Satilla Shores? What, I need something more specific.
Yes, Judge, at this time, Ms. Olivier will give you a proffer for the 4 witnesses we intend to tender.
Your Honor, the first one, Ms. Flowers, she should testify that she has seen him running in the Fancy Bluff, Boykin Ridge area, which is where he lived. She also saw him running on Highway 17, which is the highway that separates Satilla Shores and Royal Oaks from that Fancy Bluff area. So in that area surrounding Satilla Shores.
Anything more than that? Time of day, whereabouts on 17?
He would run all day, you know, during the day. Also, she's seen him during the nighttime hours. She's also seen him on Highway 303, which is also called, I believe, Blight Island Road. So night, daytime, she's seen him all times, Judge. And she will also get into the clothing that he would wear when he runs. And I think that's about it for her. We intend to tender the in-life photo through her as well. And I don't know if the court has a question for me before I move on to the other ones.
Nope, go ahead.
Okay, so Linda Randall, she lives on Andy Tottenson Road. She's gonna testify that she also saw him running in that neighborhood, and he would run for long periods of time. And the way he would be coming in terms of the direction, in addition to the timing, she would say that he would probably be running out past Highway 17 in that Satilla Shores, Royal Oaks area as well.
Sorry, that he would probably be running in the area past Highway 17.
Highway 17 and across the highway to the Satilla Shores, Royal Oaks area.
That she had direct knowledge of it, or
She saw him.
she saw him run across the road?
On Highway 17.
Yes, so she saw him the way her house is positioned. She would see him going and then coming back that direction, where the entrance to Highway 17 is. Danielle Stoddard will testify that, similarly, Judge, that she saw him in her neighborhood, Fancy Bluff neighborhood, and she would also see him around that Highway 17 area when she would be bringing her kids back from school. And Ashley Wittenberg, she will testify that she saw Ahmaud running in the Boykin Ridge neighborhood, that she would see him running at night when it's dark, which of course is an issue in this case because we have the defense attorneys saying, you know, he's in Mr. English's construction site at nighttime, what could he be possibly, you know, doing there? So she'll testify to the nighttime running as well. And those are all the witnesses we have to testify on that subject. Okay.
Well, I'll tell you, at this point in the evidence, what I have got in my notes is that the issues that have been raised, I think the first one was through, I think it's Ms. Parr, maybe her parents were the Parrs, but Ms. Parr. She was asked specifically by the defense about whether or not she had seen Mr. Arbery running in the neighborhood. Mr. Albenze was also asked about whether or not he had seen Mr. Arbery running in the neighborhood. I have not heard the questions asked, but based on the proffer, the court's concern is that none of these witnesses are actually testifying or rebutting any evidence that has been brought out by the defense. And the evidence itself would require one to make that logical leap that the court's concerned about with other evidence on why Mr. Arbery was in the neighborhood at the time. They don't actually place him in the neighborhood at any time. So again, the court's, if I'm being asked for a ruling without hearing the evidence, the court is indicating that if this is the type of evidence that comes out, at least in the state's case in chief, depending on how it's worded, it may end up opening the door to the why question that I have addressed in other orders of this court. Now, whether it has to come, whether this comes out as rebuttal at some point, it really depends on the evidence presented, because again, what I have heard is that there is evidence from witnesses that was elicited by the defense that witnesses did not see him running actually in Satilla Shores. There are other questions here that sounds like are out there, like what clothes he wore when he ran. That is not something that has been brought out at this point, as I recall, as far as evidence or argument. The time of day, that the times of day, I guess, that are involved in the various incidents that are before the court. So this could be rebuttal, but as far as the state's case in chief, strikes me as this gets us to the why question.
Understood, Your Honor. At this time, we will then just call Carol Flowers solely for the in-life photo, and having discussed that at the break with defense that may be your ruling, we understand where the defense is going to go with Ms. Flowers and where we're going to go with Ms. Flowers. So if we may have 5 minutes just to make sure we're on the same page as a team, we'll go ahead and do that.
Let's take a 5-minute recess.